A very good evening to you, ladies and gentlemen. I am happy to welcome you to the 14th webinar of Series 6 on Basic of Law, titled Applicability of State Lands in the Practice of an Attorney at Law. This is the 45th BSL webinar for the years 2025-2026. This webinar series is organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the chairman of the Webinars and Legal Symposiums Committee and the president of BSL, Mr. Rajiv Amarasuriya, the co-chairman, Mr. Chatur A. Galhena, secretary of BSL, and Mr. Pasidu Silva, treasurer of BSL, and the conveners, co-conveners, and the members of the Webinars and Legal Symposiums Committee. I would also like to extend my heartfelt gratitude to the executive committee of the BSL for all the support and guidance. For today's webinar of applicability of state lands in the practice of an attorney at law, we have with us an esteemed panelist, Ms. Daphne Pires Visundara, Senior Attorney at Law. Ms. Pires Visundara obtained her Bachelor's of Law degree from the University of Colombo and thereafter took oaths as an Attorney at Law of the Supreme Court of Sri Lanka in 1988. She also obtained her Master of Law degree from University of Colombo. She is the senior partner at D&D Law Chambers with practice areas of litigation and dispute resolution, competition and antitrust, notary, construction, testamentary, tax law, foreign investment, family law, and real estate. I warmly welcome Ms. Daphne Pires Visundara, Senior Attorney at Law, for today's session. To moderate today's session, we have with us Ms. Lahiruni Ekanayaka. Ms. Ekanayaka is an attorney at law and the head of Department of Law at Esoft University, Colombo. She holds an LLB from the University of Colombo, a master's in human rights from the same institution, and is currently pursuing an LLM in commercial law from the University of West of England. With a deep commitment to human rights, legal education, and youth empowerment, she actively engages in academic leadership and collaborative initiatives that promote access to justice and contemporary legal reform. I also warmly welcome Ms. Laharani Ekanayaka, Attorney at Law, for today's session. And without any further ado, I invite her to commence today's proceedings. Over to you.
Thank you very much, Isuri, and it is such a pleasure to be moderating today's discussion on the applicability of state lands in the practice of an attorney at law. So state land is an area that every practicing lawyer inevitably encounters, whether in court, in conveyancing, or even when advising clients on development projects. It is a topic that sits at the intersection of property rights, administrative authority, and public interest, which also makes it both complex and fascinating at the same time. So we are truly privileged to have Madam Daphne with us today, whose vast experience brings both practical and academic depth to this discussion. So Madam, to set the stage for our discussion, could you start by explaining the concept of state lands and why understanding it is so crucial for an attorney practicing in litigation?
Good evening, Isuri and everybody in here. And I'd like to thank the Bar Association of Sri Lanka for conducting the seminars like that which would help all the lawyers. For your question, come to the topic. Actually, the Sri Lanka, the applicability of the state land. When you say state lands, I would like to give my lecture on two broad topics, that the state land applicability to a practicing lawyer in courts of law, and state land applicability in the notarial practice. How you, what is the knowledge that you should have in these two areas? Now, to begin with, I would like to give the broad definition of state lands. Now, when you say state lands, the state lands can be twofold. That is, the lands directly belonging to the state, which say in Sri Lanka, the government of Sri Lanka. So then these lands, the powers and authorities are with the president. And then there are another kind of lands that is also known as state lands, that is the lands belonging to the state institutions, government department, and corporations. Now, the powers of those lands are exercised by the authority that is given in the statute itself, by which the such institutions are formed. Now, for example, if it is, we say, Land Reform Commission, so then the statute that established the Land Reform Commission gives the specifically states who exercises the power. So that has to be exercised by according to that way. Now, when you say the state lands, the law pertaining to the state land, now you should know that our common law is Roman Dutch law. So the land law is Roman Dutch law, but however, these state lands, the law governing the state lands are, or I rather say, have been substituted by the different numerous statutes pertaining to the subject. So I'm going to discuss on all these, most of these numerous statutes, which have given the provisions pertaining to the state lands.
Right, madam. So with that, I mean, as you said, now let us move into the legal framework itself, right? So could you walk us through the key pieces of legislation governing state lands, particularly the ones that distinguish between statutes that deal with already existing state lands and those that enable the state to acquire private lands and convert them into state lands for public purposes?
Yeah, as you have rightly categorized that, now we have to look into that fact on those two subjects. The statutes making provisions for the lands, which are state lands, and also there are statutes which intermeddles with the private lands, rights of the private individuals, and acquire those rights into the state. And then those lands will become state lands after that process. So then I would like to extend my discussion on those two areas, the statutes of the state lands and statutes which enables the state to acquire private lands and make them state lands for various purposes. So if you take the first category, that is the statutes making provisions for the lands which are state lands. First of all, I would like to take the first statute, the State Lands Ordinance. State Land Ordinance, this is an ordinance which make provisions for the grant and disposition and management and control of the lands which are treated as state lands. What is state lands? That is given in the interpretation section 110, which says state land means all lands in Sri Lanka to which the state is lawfully entitled or which may be disposed of by the state and includes all rights and privileges attached or appertaining to such land. So that means the lands which are directly belonging to the state are governed by this statute. Now, this, according to this statute, all the powers of the state lands, which is described in the statute, the powers and authorities are with the president as per section 3. Then we move on to another important statute, the Land Settlement Ordinance. What is Land Settlement Ordinance? The Land Settlement Ordinance is there is a settlement officer. So then the settlement officer investigate into title and he identify and declare the lands as state lands or the ownership of the private ownership also that can be done. Now, the importance in this statute with regard to the state lands is that when the settlement officer make an declaration stating that a certain land is belonging to the state, so that becomes state lands, and it is an absolute decision by the officer. That normally it is done in this manner. He makes a declaration. He will ask for the claims, gives a certain period, and then ask for the claims. And if no claim is found within that period, or the person who claims could not prove his title within that period, those unclaimed and abandon all the lands that he declares as state lands. So like that, the land settlement ordinance also has declared certain areas as state lands. Then now earlier this area was covered under the wasteland ordinance, but this land settlement ordinance is more wider in scope. It enabled the government to settle lands claim in a better manner. And then I move on to the State Lands Encroachments Ordinance number 12 of 1840. This enables the state to reclaim the lands that has been encroached by third parties. Now I will discuss another ordinance like that is State Lands Recovery of Possession. Actually, in practice today, at present in practice, mostly the encroachments that has occurred on state lands are handled. I mean, the possessions are recovered under that statute. I will go into that detail into that statute later. And then again, another important statute is Forest Ordinance. You will very well know all the forest in Sri Lanka or in any country. Forests are treated as belonging to the state. So then state exercises the powers and all the authorities with regard to the forest in Sri Lanka under these statutes. As I told you, the State Land Recovery of Possession, this is a very important statute because you might experience the provisions of this statute in court of law, because most of the time when there is an unauthorized possession in a state land, the state authority recovers to eject that unauthorized persons from the state land under the provisions of this act. Normally, this is very vital, and this is always in operations that in those who are practicing in magistrate court must have experience. There are numerous legal proceedings are filed under this statute. Now, as you say, the scope of the statute is to make provision for the recovery of possession of the state land. Now, it happens in the practical way. It's like that. If there is an unauthorized possession in a state land, there is a person called, the act has named a competent authority. Competent authority quick notice. who can, it's state land, and who can file that application, state land. And I said that only the competent authority can file this action and issue state land. As per this act, earlier, as we knew, the state land was operation. Those were also given this power to file this action in the magistrate courts so as to recover their position. I give you a good example because I have the experience of appearing in most of the cases with regard to the estate lands. Estates lands, there are numerous encroachments, and also not only encroachments. Now, in the estates, the quarters or then the lands are given to them to reside while they are in employment. We can see now when they retire or when they are you mean fired from the employment, still they hold on to the promises that was given to them. So then it becomes unauthorized possession. So the CAT has given a very speedy procedure, because this is very, very speedy procedure to recover that, recover the possession of that land to get ejected. So as I told you, the procedure is, there is a format that is given in Form B. The quit notice should be in accordance with that format, where it is issued to the person who is in unauthorized possession. And then thereafter, if he doesn't vacate within that period, application in accordance with Form A would be made to the magistrate courts. That magistrate court applications are made under section 3 of that, and then thereafter the magistrate will issue notice to the person who are in unauthorized possession, and then asking him to show cause why a ejectment order should not be issued against him. When I said show cause, right? Can you show cause, give show cause in any manner? No. Let's say I have no place to go. I have been here for so many years, like that. No, I mean, those are not the reasons that can be given under this show cause. The only show cause that can be given as per section 9 is that he is holding the land under a valid permit issued under a written authority of the state, granted in accordance with any written law. If that is the case only, that the magistrate will not issue any ejectment order. If the person who is in unauthorized possession fails to show cause, or if that show cause does not come in within the purview of section 9, then definitely the ejectment order will be issued. And then that ejectment order, with that ejectment order, the court will give the assistance of the fiscal to put them out and get the vacant position back to the state. Now supposing, now I have said, the only show cause that can be given is that they have upon a valid permit issued in accordance of the state, granted in accordance with a valid written law. Now supposing that the competent authority has made a mistake. I own my land, I have a private ownership, and competent authority make a mistake and issue a quit notice against me, and I don't have a valid permit issued by the state because I have a good valid title for my land. But the magistrate's powers are limited. The magistrate's hands are tied. They can only accept, accommodate the show cause that that person is holding under a valid permit. Now, what is my remedy then in that case?
Madam, I'm
I
extremely sorry to interrupt you, madam, but according to the information I have received, some of our audience joining from the YouTube live stream are not able to hear you properly, madam, because of a technical problem. In that
yeah.
situation, would you be able to quickly summarize the whole idea in terms of the practical implications that were brought by the State Lands Recovery of Possession Act 1979?
All right. Okay. From that point only. As you said that
Yes,
the
ma'am.
State Land Recovery Possession is an act
Yes.
designed to recover the possession from the unauthorized possession, from those who are in unauthorized possession. Supposing somebody goes and occupies a state land unlawfully. So then in that case, however period that expires, that he holds it, the state can file action under this provision, under the provisions of this act, to recover possession. There, to recover possession, I said that there is a competent authority. Competent authority is different from state institution to institution. That is given in, I have given under the interpretation ordinance, who is the state competent authority in respect of different institutions, and in the case of a state land. And then I said that when he makes an application to the magistrate courts send notice and ask for the show cause. That I said the show cause can only be limited to show that the person is holding under a valid permit issued by the state. That is the only show cause that is given. And thereafter I went to the question, that if I don't have a valid permit, but I am holding the land through correct title, say it's a private land, I have clear deeds, I'm holding it under a clear deeds for a long period of time, it is not a state land, the competent authority had a mistake by issuing a quit notice against me. What is my remedy? The magistrate can't hold inquiries and investigate into the title. Magistrates, the powers are limited. So then, am I without any remedy? No. Actually, the act has given a remedy for me, for a person like that who holds the land as per a valid title, but not the permit issued by the state. And such persons can vindicate their title under Section 12. The vindicatory action is to prove my title in the district court. And then, but remember that application has to be made within 6 months of the ejectment order. And if you can prove your title in the district of court, you will not be rejected. Huh? So that is the scope of the act.
Right. I think that gives a very comprehensive breakdown in terms of how the procedure works with regard to the issue at hand. And with that, now that we have looked at the idea of the recovery of possession, let us also turn to the broader question of acquisition. So, in this particular context, how does ejection and acquisition process work under the Land Acquisition Act number 9 of 1950? Would you be able to outline the procedure that is generally followed under this statute as well?
So that means that we are going to the second category of the statutes, that is the statutes which enables the states to acquire private lands and make them state lands. So you're asking this question under the Land Acquisition Act, how it operates. Before that, I would like to, now there is a very important act which enable the state to acquire lands from the private ownership. That is Land Reform Law. You should know Land Reform Law came to effect in 1972. Actually, it was mainly on the estate lands. It made a big difference in the estate sector. Our tea industry, rubber industry, those were managed by the private companies. And then this land reform law came into operation. Those lands, the estates lands, the big lands vested with the state. For that purpose, they establish a body called Land Reform Commission. And according to this statute, under Section 3, the legislature made a ceiling on the land, agricultural land, that can be held by an individual. Section 3 says that you can hold a maximum of 50 acres highland and maximum of 25 acres of paddy land. If you have anything more than that, as per Section 3(2), it automatically vests with the Land Reform Commission, right? So with the operation of the law, it automatically vests with the Land Reform Commission. Then, how do you now, if you have more than, if 50 acres and the balance, now you are allowed to keep 50 acres. Supposing that you have 200 acres, we say. So now, according to that, it is not the statute is taking only 150, leaving 50 for you. No, that is not the procedure. As per that, the entire 200 acres would be vested with the Land Reform Commission. Then, now the law has allowed you to keep 50 acres. For that, you'll have to make a statutory declaration to the Land Reform Commission saying that, so giving all your ownership, and also it says that each individual, in the family also, the children all, according to certain limitations, were allowed to keep 50 acres. And also if it is a company, each shareholder was allowed to keep 50 acres, like that. When you make that statutory declaration, then the Land Reform Commission inquires into that statutory declaration and makes a statutory determination in your favor. And then you are getting this land from Land Reform, although it is your own land. Thereafter, then it goes to the Land Reform Commission. You are getting it from the Land Reform Commission, but is allowed you to keep under the ceiling that is given there. Now, as I said, that most of these estate lands that is belonging to the Sri Lanka State Plantation Corporation, Janata Estate Development Board, you can see that there are a lot of estates, tea estates, rubber estates around the country. Now they are owned and managed either by Sri Lanka State Plantation Corporation or Janata Estates Development Board. That is under this Land Reform Commission. The lands that were vested with the Land Reform Commission could be used to utilize for so many purposes, that this agricultural purpose, these estates were managed by, so earlier they were given to these two institutions, Sri Lanka State Plantation Corporation and Janata Estate Development Board, and then thereafter they were vested with those institutions under Section 22G of that Act. So now, with regard to those estates, Land Reform Commission has no power any longer. But however, we can see most of the cases in the courts, still Land Reform Commission intervenes into the matters in these with regard to these estate lands, and still they are claiming ownership, saying that the what is the extent mentioned in the gazette is less than what they had, like that. Actually, now there are very clear decisions made by the courts that once that order is made under Section 22G, vesting those lands with the State Plantation Corporation, Janta Estate Development Board, the rights of the Land Reform Commission comes to an end. And I go to Land Acquisition Act. You made that question. I will just briefly say you the procedure that happens under the Land Acquisition Act before coming into the law, the decided case pertaining to this area. Now, under this Land Acquisition Act, there are certain, actually it is done by way of gazette notifications. Ministers' orders are published by way of gazette notification. Now, we say, all those notices as Section 2 notice, 5 notice, 7 notice, like that, it operates. Now, under Section 2, the minister's decision that the land in area is needed for public purposes, they published. And under Section 5, the minister decides that a particular land or servitude should be acquired. And under Section 7, they call for the compensation for the lands that was acquired. Under Section 9, the inquiry is made into claims. Section 10, decision of the acquiring officer about the claims. And under Section 12, now supposing that when there is under this inquiry, there are competing claims by 2 different or 3 different persons, which the acquiring officer could not make a decision. No, he is just a public officer, so he might not have a competency to decide on this title. In such an event, this will be referred to the district court for determination who is entitled for the compensation. And after that, the award of compensation is given. And there is a special important section there, Section 38A. Now, if a certain land is urgently required for the public purpose, they will, without going through all these process, they will make the acquiring officer can make a vesting order directly under Section 38A, like that. Now, you said that litigation and this Land Acquisition Act, as I said, that one mode of litigation is when there is a competent claims by different persons, and when the acquiring officer is not able to decide on that, he will refer it to the district court. So in the district court, you'll have to prove your title, and then you have to prove your entitlement for the compensation. That is one way of litigation. And also, now when we can see the lot of cases when all of a sudden, when government makes a decision to acquire private ownership, sometimes we have come across a situation, my own house, only one house that I have, but it is required for public purposes, maybe road widening or certain other this thing. Therefore, in such a situation, can I challenge that decision of the minister? Actually, although the operation is done by the competent authority, the decision is made by the minister. So can I challenge that order of the minister, decision of the minister published that my land is required for public purpose. Actually, there are the remedies. Then, in such a situation, the remedy is always by way of writ of certiorari. That you know that writs are available to question the legality of the public administrative officers. Under that provision, you can file a writ of certiorari or writ of mandamus to the Court of Appeal. So that is how we are questioning the validity of a decision of the minister. Now, do you think that the minister's decision can be challenged? I must say, to my experience, the courts are very slow in accommodating your applications, challenging the minister, because for the reason that when a land is required for public purposes, just by litigation, you can't delay that public purpose. It may be a very important project, the land is required. So then in such a situation, the courts are very slow in giving a decision against the minister. However, now if supposing that if it is illegal, that is the minister is acting outside his jurisdiction, and also procedural impropriety, that means that the acquisition has been made without following the proper procedure, and also irrationality, because this we can experience sometimes for the extraneous reasons. Sometimes we have experience for the political reasons, just to harass the political opponent. There are instances that their lands have been acquired. If you can clearly prove that these lands have been, the decisions have been made, or acquisition is going to be made for extraneous reason, and it is clearly not for the public purposes, then in such events, the court definitely would accommodate your application, and sometimes they might give certiorari. Certioraries are given to quash the decision of the minister to acquire that land, particular land, for the public purposes. I have given you a few cases, and that these are only few instances where the court has decided that what are the areas, what are the instances that you can validly question the decision of the minister. Now, this you can see that this Gunasinghe versus Hiran Gunasekara versus acquiring officer, it has been said that it can be challenged, but in Gunasekara versus Honorable Gamini Disanayaka, actually there was a good reason for this application, but however it has been made after the section. I said that there are certain gazette notification public section 2(5). So then after section 2(5), publication is notice is published. That is the minister's decision to acquire the land published. After that, the court has decided it cannot be easily questioned, although that it is maybe for improper purpose. But however, mala fides, if you can completely show that it is completely mala fides, the court will accommodate. But however, when you have passed the section 5 notice, or it has gone into section 38A, then your chances of winning is very low. That is why normally the states, they without going through all the procedures, they at once, most of the time, at once they publish 38 just after the section 2, they quickly publish Section 38(2) so as to defeat any challenging applications being made. So that is normally the normal purview of the cases, the normal attitude that is taken by our courts. And
Right.
there is another area of litigation under that, the compensation that I said, that there is a compensation. If the compensation that is decided by the acquiring officer, if you're not satisfied with that, you can make a appeal to the Board of Reviews under Section 22. But however, the Board of Review, their limits, their powers are very limited. Normally, the maximum they can offer you is as a revision is the double the amount. From there, you have another application appeal to the Court of Appeal. And there is another area, that divesting orders. Divesting, I said that vesting orders, acquisition officer. Then there are two instances that you can, there is a spelling mistake, it should be divesting orders. Divesting orders can be made, right? That is under Section 39 and 39A. Divesting orders can be twofold. One is that completely revocation of the order, that the state has made a acquisition order, published acquisition order, but later the court, the state thinks that, okay, that this project is not viable, we don't need the land anymore. Then under Section 39, a revocation of that order can be made. And the Section 39, but when you, under Section 39, to make a revocation of order, one criteria must be satisfied, that is the possession of the land might not have been actually taken. That requirement should be there. But maybe now there are instances the state has actually taken over possession, but however the land has not been used for that purpose. Then in that event, they are making the divesting order. That means reversing that order. So then it will go back to the original owner. But to make such an order, certain things must be satisfied. That is the actual possession, it has not been used for that purpose. No compensation has been made. And land has not been used for that purpose. No improvements has been made. And also, the person interested has consented in writing to take possession. Now, this requirement is there. Sometimes we can see the government has published a vesting order and they have not been used, that those lands are not being used for the purpose of just idling. And then political people, they might come and say, okay, we can do put an divesting order and claim for that land. But that cannot be done because the land has to go to the original person, and that person interested must have consented in writing to that possession. That I have said that writ of mandamus, right, you know that writ of mandamus means the compelling the administrative officer to do a certain thing. Now, under Section 39 and 39A, if these requirements are satisfied, the original owner can invoke the jurisdiction of the Court of Appeal to compel the minister to make orders under Section 39 and 39A. Those are the purview of the Land Acquisition Act.
Right. And before we actually move into the next segment of our discussion, I would like to make a quick reminder to the audience joining us in terms of the Q&A session that we will be having after the next part of the discussion. And any questions you all can type in the Q&A box, and we will try our level best to get them answered, balancing our time constraints as well at the same time. So with that, thank you very much, Madam, for that very comprehensive and detailed explanation in terms of balancing the interests between what exactly comes under the scope of public purpose as well as the interests of the private. And with that, let us now move on from litigation to the notarial side of practice, where due diligence is key. So, when investigating title, notaries have to be extremely cautious in determining whether a particular land has been vested in the state or a state institution. So, in this particular context, what are the key responsibilities of notaries in these situations?
Yes, now the notaries has to be very careful now in investigating title because of two reasons. That when you are investigating title, normally we, as you are aware, if there is 30 years of title, we will say, okay, we have a good title, and then we can recommend the title to the customer. We can say, no, we have good 30 years long, undisturbed and clear chain of title. But however, now supposing this is a state land without your knowledge, then the 30 years, whether it is 30 years or 40 years, the title is not good because of the reason that prescription does not cannot be claimed against the state. You know that according to prescription ordinance, section 15, we cannot claim prescription against the state. If this is a state land and somebody is holding that and then they are in possession, they have been writing deeds with regard to that land without your knowledge, and this is, then you don't know that this is belonging to the state. The state lands can be, I said that state land can be that they are per se it's state lands. And also I said that say it can be made state lands, and I think I have not, I will just quickly go through the other areas, other acts also. I said that land reform, land acquisition, and again, Urban Development Authority Act. Under that act, for the purpose of urban development, the government can make compulsory acquisition under Section 16, and under Thoroughfare Ordinance, the government can make vesting orders for the roads, and also under Flood Protection Ordinance, there is provision for the state to make acquire the lands. Road Development Authority, the lands can be acquired for the purpose of roads, and especially the land reclamation, and the Sustainable Energy Authority Act, that is for the, if that area is necessary for the sustainable energy projects, the Sustainable Energy Authority has the power to acquire such land. So like that, and then the Land Development Ordinance, under the Land Development Ordinance also, the government has the right to acquire lands for the various purposes like major colonizations, village expansions, highland settlements, so on and so forth. Like that, we'll have to be very sure that this has not become state land under any of these statutes. If it has been acquired, or if it is a state land, however long that has been held by the previous owners, you are running the risk of having been ejected at any moment if it is state land. So therefore, the notaries has to be very careful in checking whether, when they are dealing with the investigating a title, whether the land is a state land or not. Sometimes we find cases, the land has been acquired, and Land Acquisition Act, the only problem is now they are not registering, although there are provisions to register these acquisition orders, they are not registering in the land registry. So therefore, sometimes you get misled, and later only you come to know that this has been acquired, and by that time that fraudulent persons, without letting you know that it has been acquired, I will sell it to you and go. So then your client will be in difficulty, and definitely you will also be responsible, because as a notary, you are responsible to investigate the title and to recommend the title to your client. That is one aspect that the notary should be very careful about the state lands. And also I said that there are certain statutes which are dealing with the state lands, like that development ordinance. Land development ordinance, when that is acquired, under this land development ordinance, the government is making grants and permits. You must have heard the Swarna Bhumi, Jaya Bhumi, Isru Bhumi, those certain grants that have been made by the state. You have to be very careful. Now, this Swarna Bhumi, Jaya Bhumi, those grants under the land development ordinance, the title is very good because it is coming from the state title. But however, the grants always are subjected to certain conditions, because it is for specific purposes. These grants are given, maybe for those who does not have lands, and those who don't have houses to live. So then the government would see that they will use it for that purpose. For that reason, there are certain conditions that they are attached with. Like that if you want to dispose that land, it says that it has to be subject to certain conditions. Like you have to get the consent of the acquiring, not the acquiring officer, the government agent, and you can't subdivide it into less than 10 purchase, like that. Those conditions applies not only to the first owner, it goes down to the other successive owners as well. So therefore, when you are dealing with the Jai Bhumi, Swarna Bhumi, those land development ordinance grants, you'll have to be very careful that you have to apply the correct procedure. If you have to get the consent of the government agent, or the divisional secretary, or sometimes the Commission of National Housing. I think that Commission of National Housing's consent is no more, because that National Housing Act has removed that Section 8 with regard to the apartments. But in other cases, when those provisions are applicable, the notaries has to be very careful. They'll have to follow that procedure. Now, there I have come across situations, they will write the deeds not according to that procedure. The land, there is a special registers maintained in the land registries. We call it LDO. LDO registers. Without registering in the LDO, I have come across situations, the lawyers, they most of the time notaries, they do different deeds from that person to another one without following the procedure set out in the Act. Then Section 162 says those dispositions, the notarial dispositions, are not valid at all. The same way, now there are certain other acts also says that you have to, when disposing such lands, you will have to follow certain procedures that has been, I have given instances in the note. be careful that when you are dealing with such things that you have, you comply with those provisions without when before recommending the title, way before attesting the and preparing and attesting deeds.
Right. So, in that sense, I think like my next question is also inherently connected with the discussion in terms of the responsibilities of the notaries with regard to this particular aspect. So, when investigating a title in connection with this, what are some of the common offenses that are committed by notaries in relation to state lands, and how can these be avoided through ethical and diligent practices? Would Madam be able to elaborate a bit more on that as well?
Yeah, that's very good that you reminded me. You know that I said under Section 162 of the Land Development Ordinance that the notary is obliged to follow certain procedures that is given in the Act. And if you do not follow that procedures, and if they are executing deeds without following that deed, not only such deeds will be invalid. As per Section 163, the statute has imposed penal obligations on the notary. That is, I think there is imprisonment as well. The notary can be subject to imprisonment for the contravention of the provisions in the ordinance. So therefore, you should, or maybe that sometimes you find another lawyer has done a deed, okay, then you might see, okay, no problem, now he has done the deed, now it has gone out of the purview of the land development ordinance. There is no harm in my writing another deed. Don't do that, because Section 163 impose penal obligations on the notary who executes deeds against the provisions of that ordinance. And also, then there is, according to the land reclamation ordinance, there are certain areas that has been barred in filling, because they have to be kept as the low areas for the water the water flows, and filling those areas also attaches a obligations on the people, and also the notaries who write deeds on those areas also might be subjected to the penal obligations on that. So therefore, that is why I said that not only the litigation, the notarial, those who are in the notarial practice also has to be very mindful about the state lands in their practice.
Yes, and that actually brings us to the end of the discussion for today. And we also have a few questions directed to us as well in terms of the topic at hand. So I'll straight away dive into one of those questions. So there is this idea that certain politically motivated people claim the idea of some lands belonging to them, and also claims in respect of the fact that those lands are identified as lands of their people. So, in such a context, how would the application of law work with regard to these politically motivated claims in terms of what really falls into the category of lands of the people or lands that belong to the homeland? Will you be able to share your thoughts on that, madam?
Just for I don't think that the political people can have that power on the lands, but certainly what this the political intervention that can be made is by the minister, as I said, just to harass the political opponents. They might publish notices under Land Acquisition Act to acquire property. We have experienced so much of instances like that. The political opponents' lands, the very valuable lands, they make notices under Land Acquisition Act. As I said, that those actually those are, if those are done for mala fide, for extraneous purposes, and if that public purpose is not justified, but there should be very, very concrete evidence. You have to prove that in a very strong way, in a stringent way. If you can prove it, definitely you can protect your land rights.
Right. We also have another question. So this is actually falling under the Land Development Ordinance. What if a divisional secretary appointed a grantee to a relevant grant under Section 72, read with Rule 1 of the third schedule of the ordinance, disregarding the nominations done by the original permit holder of a grant? Can the nominee challenge the divisional secretary's act after considerable time has been passed, let's say a tentative time of around 5 years?
Yes, in my personal opinion, because the Act has clearly given provisions how the succession should be done, nomination should be done, and definitely supposing that if he has not done the nomination during the lifetime of the holder, that can be done by way of a last will. So then last will has to be proved, the probate has to be obtained, like that. There is a very stringent procedure. So the divisional secretary cannot go beyond that legal provisions, that if the divisional secretary acts beyond its authority, definitely we can question that by way of a writ of certiorari under to the making an application to the Court of Appeal.
Right. Is there anything in addition to what we have discussed today that Madam would like to add, which you believe would be beneficial in terms of the topic at hand with regard to making the audience aware in terms of like what the notaries as well as the lawyers need to look out for in terms of this idea of applicability of state lands in the practice of an attorney at law as well as in the notary practice?
As I told you, because sometimes you might find this in the courts that we are faced with lot of problems with the Land Reform Commission, because I have told you that after the Land Reform law, when those vesting orders made under the made in favor of the state plantation corporations and Sri Lanka State Plantation Corporations and Janata State Development Boards, there are numerous occasions. Still, this Land Reform Commission makes claims. And also, I have come across a lot of instances, Land Reform Commission gives dispositions, that you mean the transfers, make the conveyances of the lands which are already vested with these two institutions, claiming that it is belonging to the ITs most of the time, because they are to find money, things like that. For those reasons, they are doing that. So sometimes we have come across situations, the people, they have made huge monies to the Land Reform Commission, but still it does not get any title, because now there are recent judgments in the Supreme Court as well as in the Court of Appeal. Now, with regard to the lands that were vested with this institution, Land Reform Commission does not exercise any more rights with regard to that, because those are the statute provisions are very clear. So therefore, be careful when you're dealing with the Land Reform Commission. Sometimes they might give you conveyances which are not valid.
Right.
I said that out of my experience.
Right. We also have another question, Madam, to explain how the concepts of priority and registration work in terms of acquisition as well as the procedure at hand.
There is, I think, under acquisition, say, I don't remember the section 17 or something. There is provisions to register that acquisition, and they must do it. But, very unfortunately, these acquisition orders are not properly registered in the land registries. So, due to that reason, most of the time we have come across situations, the original owners, without letting them know the fact that their land has been acquired for certain public purposes, they still sell the land to another person and then putting that person into trouble after spending so much of money. I think that it is for the government or the state institution to compel them to register each and every acquisition. Otherwise, that the public will get misled and then they can be subject to the fraudulent activities. I hope that would suffice your question.
Yes, and I think with time constraints, we do not have time to go through the rest of the questions, but I think we have answered most of the questions that were posited by the audience. And with that, this also brings us to the end of the discussion at hand today. And thank you so much, Madam, for that very insightful and practical discussion. It really helped us understand how the particular law in this regard connects to our everyday work, both as attorneys as well as notaries. And also, I would like to thank the audience for your participation and engagement today. And I would like to hand over the controls back to Ms. Isuri.
Yeah, thank you so much. Good night, everybody.
Thank you, madam. This brings us to the end of the 14th webinar of the series on basics of law, titled Applicability of State Lands in the Practice of an Attorney at Law. I thank our esteemed panelists, Ms. Daphne P.D.S. Visundara, Senior Attorney at Law, and our moderator, Ms. Lahirini Ekanayaka, Attorney at Law, for the fruitful and educational discussion, and for dedicating our time to be here with us and sharing your insights. I thank the BSF Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this insightful webinar. I also extend my thanks to all of the participants who have joined in for the session today. Thank you, and I hope you have a very good night.
Thank you.